Right, this is case number 11116872. This is Community Alliance Center versus Lawrence Gist. Matters before the court on an application or on the issuance of a subpoena. Your appearance for plaintiff regarding this matter. Do I have plaintiff for Community Alliance Credit Union? Do I have Lawrence Gist, last name Gist, G-I-S-T, Santa Rosa Street? All right, no response in that regard. The court will likely dismiss the subpoena. I will recheck at the end of the call on that matter. The court now calls case number 20151346. This is Michigan Basic Property Insurance versus Daryl Anthony Hendry. Matters before the court on the issuance of a subpoena. Your appearance for Michigan Basic. Michigan Basic. All right. This regards the issuance of a subpoena. Neither party has appeared. The court will likely dismiss the subpoena. I will recall the matter. The court now calls 21-57927. This is Monroe Community Credit Union versus Michael James Discus. Your appearance regarding this matter, please. All right, it appears, do I have Mr. Discus, Michael Discus on the Zoom? All right, I was set on for a, after issuance of a subpoena, and it appears that the defendant, that the plaintiff or either party has appeared in regard to that matter. This is case number 21-156744. This is Universal Collections versus Annette Rogers. The matter is before the court on a motion for reconsideration. Your appearance at this time, counsel.
Good morning, Your Honor. I'm sorry, Lateef. Go ahead. My apologies.
Okay. Good morning, Your Honor. J. Lateef Baig, B-A-I-G, P36820, appearing on behalf of plaintiff and the attorney of record. I'm stepping in for Mr. Warner today.
Good morning, Your Honor. Brian Muad, P41209, appearing on behalf of the defendant, Annette Rogers.
All right, thank you. And I believe that this is your motion for reconsideration. Is that correct, Mr. Muad?
It is, Your Honor. Correct.
All right, you may at this time, sir.
Judge, back in November of 2021, we were in front of you with Mr. Warner, and that was on my motion to quash. I had suggested to the court at that time period that we do an evidentiary hearing. The court was kind enough to adjourn it to late December of 2021. Unfortunately, myself being in the back of the office here, I wrote down the date for December 21st, but unfortunately didn't make it into my book. My understanding is that this honorable court did have the hearing. The process server, I believe, was in front of you. He indicated what he based his service on because we were contesting service, and the court basically indicated that the service process was legitimate, and we moved forward. As soon as I found out about the date, I filed the motion for reconsideration on the basis that my client, in the way that was described in the affidavit of the process server, saying that he served her with papers, described her as a Black female in her 40s, 5 feet 6 inches tall, and about 170 pounds with dark hair. My client is on the Zoom hearing with her daughter. As you can see, Your Honor, she's about 115 pounds, 5 foot 3 inches, and not 5'6". And her and I are pretty close in age, around 60. So we're not talking about the same person he put the paperwork in his hands. And therefore, our position is that we wanted to indicate that court reconsider its decision to indicate that the service was proper, set aside the service of the summons and complaint, and indicate that we did submit an affidavit of meritorious defense, and good cause being that service process was not made. It was actually made ironically, on my client's son-in-law, not my client's daughter. My client's daughter was present, and Erica Rogers was present at that time that the process server had put the papers in the hands, but it was of her husband, not, my client. My client wasn't even in the same room. She was upstairs with her grandchildren, and at the time that the service of process was made. So therefore, we would indicate that the service was defective, and that the meritorious defense was that they are indicating that my client, when she left the premises on this landlord-tenant action, failed to leave the yard in a good, pristine manner. And my client flatly indicates that she had somebody that she paid and hired to clean the yard all the time, and it was clean before she left. And some rents that she disputes that were not paid, she would heavily dispute that, because she indicated that she can declare to the court by way of affidavit, which she did, that she was up to date on her rent. I would ask, Your Honor, that the service of process that was be set aside, that was served upon on my client's son-in-law as being a defective service. And furthermore, we feel that under the motion to set aside the default, if the court were to see fit to grant, to look at this as a judgment under 2.612, set aside it on the basis of affidavit of meritorious defense and good cause being shown.
All right, counsel, obviously, I have the testimony of the process server that is in conflict with the allegations or the challenges raised under your motion. That's part of the issue, is that I have a signed affidavit in that regard, and then affidavit testing, and I have testimony moreover of the process server. Let me hear from the other side on this, counsel.
Your Honor, and you're right. You do have the testimony of the process server. You have an affidavit from the process server. What you don't have, and this is why defense counsel's motions are defective, is that if you look at the affidavit of the defendant, she doesn't speak to the service of process. I mean, she speaks generally as to the fact that she has some merit, that she claims she has meritorious defenses. She doesn't do so with any specificity. Your Honor, brother counsel, had missed 2 hearings. Plaintiff's counsel was present. We arranged for the process server to come and testify. We've incurred costs of not less than $750 with regard to this. Your Honor, we would just ask that and then our response to the motion of consideration is quite lengthy, and I'm sure Your Honor has taken a look at that, and I don't see why I need to rehash what's already before you. I would just request that you deny their motion, let the judgment stand. But if you're so inclined to grant their motion to set aside the default, to at least set this for a pretrial conference, now that she is aware of the case, it would prejudice my client if we have to refile and reserve her again, and of course to award costs. Thank you.
Thank you. You get the last word on your motion, Mr. Bois.
Thank you, Judge. There was a motion for reconsider. There's 2 motions filed. There's a motion for reconsideration on the basis of this honorable court's decision back in December that we were not present for. However, plaintiff did have his process server present in person by Zoom. Today, I have my client present by Zoom, and as it can be seen from the description it doesn't match, number one. That's my motion for reconsideration. However, if the court were to see fit to say, I want to let that decision stand, then the second motion that we filed, which was a motion to set aside the default judgment based on an affidavit of meritorious defense and good cause shown by looking at the fact that she simply does not fit the description of the process server, then we would say under the circumstances, rule in on that aspect of the motion, I would say under the circumstances, we have demonstrated good palpable cause. You don't get the papers, you don't respond, you don't answer the complaint, they get a default judgment simply because it's the wrong person, as can be seen. And my client is here to indicate to the court with testimony, Your Honor, that those papers were not placed in her hands. She wasn't even in the vicinity of that process server. So we can create, I think, definitely for purposes of the second motion to set aside the default judgment, affidavit of meritorious defense that she signed and good cause shown based on both the affidavit and her testimony, if the court were to see fit to take testimony from her. My client wasn't here last.
Yes, and I understand it. I've already, the court has considered the motion in this regard. The court has already conducted a hearing with regard to the affidavit of service in this matter. And obviously, the court can't simply look at the document that has been signed as affidavit, look at a person on the Zoom screen and say that the process server got it wrong, particularly where I've already had a hearing in that regard. It seems to me that the dispute in this matter is a dispute over the propriety of the judgment as injured, where there seem to be substantial factual disputes as to what happened in the context of the landlord-tenant relationship. And so it seems like the interests of the parties are properly joined before this court. That the major issue here is that Ms. Rogers did not respond, obviously, to the complaint, and Mr. Luab, the counsel for the defendant, would say that's because she did not receive the document, although the document from under Mr. Luab's argument was served at her home to a person connected to her, et cetera. Of course, that would not satisfy the rules for personal service, and the court is not saying that it buys that, but that would in fact mean that the document was served in her home, and et cetera. Now, I'm not making that particular finding. What I am concluding is that the court has already conducted a hearing regarding the service of process in this matter, and was persuaded by the process service information that service was in fact completed in this matter, and I stand by that ruling at this time. Obviously, a challenge to that ruling, there are various ways to do that, but at this point, the court stands by that. On a more central question at this time is whether or not the court should think about setting aside the judgment and allow the parties to proceed on the merits of the underlying case. Mr. Muad has persuaded me that there are issues that are genuine issues of material fact. I'm persuaded that whatever the failure was with regard to Ms. Rogers not responding to the court's call, that she stands ready, willing, and able to, in fact, respond to the call in this matter. And it is upon those bases and one other basis that I would set aside the judgment in this matter. Obviously, costs have been incurred. I'll set aside the judgment contingent upon the payment of costs of about $300, and then I'll set this matter on for a pretrial conference. It seems to me that one of the challenges, or one of the things parties may want to actually consider here, is talking about how to get to a finish line with this. Obviously, landlord-tenant type disputes are very, very common, and the disputes that arise after the end of tenancies are, these things are very, very common. And I noticed that the judgment that was entered here was in the nature of some $5,000. It may be worth talking about a way to get this resolved. And if you want to do that, you'll have a little bit of time to do it. It seems to me that the parties are very, very familiar with their respective positions regarding this matter. So I'm going to go ahead and set it for a pretrial conference just beyond 30 days. And I want the parties to at least approach trying to find a way to resolve this by the time. If not, my inclination would be to set it for some type of trial shortly after the next action date. That next action date is going to be just 30 days hence. That's going to be
May 3rd.
that's going to be May 3rd. Yeah, it's going to be May 3rd, 2022, and that's going to be at 9:45 a.m. May 3rd, 9:45 a.m. The court will conduct a pretrial conference regarding this matter. I've given some indications to the parties as to how I believe they should be taking a look at this matter. Obviously, there are learned counsel in this matter. Do take into consideration the broad width of experience associated with these matters and the broad width of experience that the two of you have in these matters as well. So again, the 3rd of May at 9:45 a.m. The judgment in this matter will be set aside contingent upon the payment of costs in the amount of $300. And motion with respect to setting aside or quashing the service in this matter is denied. The court stands by the previous rulings in regards to this matter.
Okay. And Judge, that next hearing, Judge, is by Zoom?
That next hearing will be by Zoom. You'll get a notice with the Zoom address and everything, just as you got for this hearing. All right. So
Okay.
note that the 3rd of May. All right.
Absolutely, Your Honor. Thank you. Thank you very much.
Your Honor, just one thing. Would you have any objection if we just conduct a quick pretrial conference now and skip the May 3rd hearing?
Well, you anticipate really what the court's thinking is regarding this. I really urge the parties to talk about this. It's been going on for a while. Both sides have an interest in seeing this resolved, and I'd like to push the parties in that direction. But again, I understand that that tensions arise, and sometimes people have to blow through it a little bit. But I see that you've been in a breakout room a little bit earlier. You still have that notification that can take you back in, and I'll stand down for a moment and go back in and talk about it in light of the court's decisions in these matters.
Your Honor, since I'm covering for Mr. Warner, I think probably the best thing to do at this time is for brother counsel to speak directly to the attorney of record to try to resolve it.
All right, and yeah, that gives you the time period that I've given you then, that gives them the opportunity to reach out to each other. And I had a little bit of that in consideration, but once you said, sir, that we're talking, I thought that you were, I thought you had put that cape on. So okay.
Okay, we'll May 3rd is fine. Thank you, Judge.
Thank you, Your Honor. Have a good week.
Well, you see, when we talk about these things, I have a lot of things running through my mind, and I always want you to talk about this stuff today. I was aware, counsel, that you were standing in for Mr. Warner, and so my thought was that, well, it might not be as fruitful without Mr. Warner being directly involved. Then you spoke up, and I'm like, okay, well, he's got the cape, so go ahead and talk about it. Back to where we're back to where a little slither of my wisdom was engaged on this from the start. So we'll see you on the 3rd at 9:45 a.m.
Thank you, Judge.
Thank you.
Thank you, Your Honor. Everybody have a good day. I'll call you, Annette.
You too.
Thank you. Bye-bye, all.
All right, this is case number 15-123-233. This is American Road Service versus Katie Reyes LS. The matter is before the court set for a pretrial conference or settlement conference. The parties did offer a stipulation asking the court will adjourn the same. Your appearance at this time, counsel.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff P number 74809.
Good morning. Oh,
You.
I'm sorry. Sorry. Yeah, good morning. Mark Linton appearing on behalf of the defendant, Katie Davis Head. Just so you know, Your Honor, I have a jury deliberating, so I don't know if they'll call me in, but I'm out in the hallway here, just trying to be able to pop on here. So I appreciate the courtesy.
All right, thank you, sir. All right, so it looks like you've asked for a settlement, an adjournment of the settlement conference in this matter, that you actually stipulated to the adjournment of the same. I know that you're here, and has there been any discussion about any of this? And I understand you're waiting for that. I'm trying to make out if that wall back there is Wayne County Circuit Court, or is it a federal court wall?
It's Washtenaw County Circuit Court.
I was wrong on all counts. All right, very well.
So, Your Honor, I had asked for the adjournment because I thought I was going to be in the jury trial. It's just I happened to hit a moment where they're deliberating, so I could hop out. So, at this point, I know Ms. Williams has taken the deposition of Ms. Davis Head, and there were some written questions. I don't know, she had expressed she might be willing to dismiss at some point. So I guess I would ask Ms. Williams what her intention would be moving forward.
Right now, I don't have a position for my client as far as the dismissal. I have presented the information to them and they're reviewing it. So right now, I don't have any authority as it relates to dismissing the action.
All right. All right. Well, it does seem that the case is in some level of motion, so I will go ahead and adjourn the settlement conference regarding this matter. I will give a bit more time to the parties to take a look at their relative positions and see what the outcome of this should look like. So why don't we set it over? Why don't I bring this back on May the 3rd?
Thank you, Your Honor.
I could bring it back sooner if you think that would be fruitful. May the 3rd is kind of what I'm looking at.
May the 3rd would be good for me because April is booked up, Your Honor. So May the 3rd would be preferable.
All right, so I'll go ahead and set it up, Mr. Lennon, for May 3rd, and I'm going to set that on for 10 o'clock a.m., May 3rd at 10 o'clock a.m. You'll get a copy of your stipulated agreement back with that particular date, and that's going to be on a Tuesday, May 3rd, 2022 at 10 o'clock.
Thank you, Your Honor.
All right. Thank you, Your Honor. Have a good day.
Good day to you, Ms. Head.
Bye.
Take care. Take care, Mr. Linton.
Thank you. You too.
I agree.
He's downstairs.
I haven't forgotten you there on Michigan Comprehensive versus City of Detroit. Thank you for your patience. Right. Case number 21-168-665. This is Lent Chiropractic versus City of Detroit. The matter is before the court, set on for a general hearing on today's date. For Lent Chiropractic, your appearance at this time. For the City of Detroit.
Tulsi Grimaldi for the City of Detroit, Your Honor, P85585.
Thank you, Mr. Maldi, and good morning to you, ma'am.
Good morning.
So I'm looking for the plaintiff in this matter. You spoken with them today. What's going on here?
I emailed him yesterday about our hearing today, and he responded a little after midnight, but I haven't talked to him since. So the city actually doesn't have a claim or any record of the underlying claimant in this matter. And I reached out to Mr. DeCrube about potentially stipulating to dismiss the city, as it appears that the accident took place on a smart bus, but he has not agreed or disagreed at this point.
All right. So you sent the email and you haven't gotten any response or you got no response from him, no feedback?
So I initially emailed him when I received the complaint on January 21st, and I did not receive a response. And then I forwarded the email to him yesterday and brought up today's hearing, at which point he responded asking if I had gotten in contact with Smart yet. And then I haven't heard from him since then.
All right, so I know council typically shows up on these matters. So what's your desire at this time, council?
Your Honor, I'd ask to have the case dismissed for failure to appear for a scheduled conference.
And you've indicated as an offer, if you will, of proof regarding this matter, that the city should not be in this matter because it was not a city bus to the best of your knowledge or city vehicle that was involved in this alleged incident, correct?
Correct, Your Honor.
All right, under the circumstances where it appears on an initial investigation by the city that they were not involved in this matter, where counsel, Mr. DeCroix, has not appeared, has been informed regarding that particular challenge in this case. The court at this time will go ahead and grant the petition to dismiss this matter on the basis that it appears that this claim would not relate to the city of Detroit, as the subject vehicle appears to have not been the vehicle that belongs to the city of Detroit. So the case is dismissed at this time.
Thank you, Your Honor.
Thank you.
Have a good day.
All right, likewise, Steve.
That's what the city of Detroit owns, right? Not for depending on the two, right?
Yeah, and not for any other, but
Okay.
the city of Detroit. It's like Smarty. Something else.
Okay.
I don't think it's service. All right, so we're on the record in Michigan Comprehensive Spine and Rehab versus City of Detroit. The matter is before the court on defendant's motion for summary disposition. The court did receive and read the motion, as well as plaintiff's answer to the motion, as well as this defendant's response to the plaintiff's answer to the motion in this matter. Your appearance for City of Detroit, please.
Good morning, Your Honor. Alfred Ashew, P82536, on behalf of defendant City of Detroit.
Thank you, Mr. Ashew. Thank you for your patience. And of course, I went out of order there. Plaintiff, your appearance for the record at this time.
Philip Jaffe for the plaintiff, P25997.
All right, gentlemen, thank you for your extreme patience this morning in waiting for the court regarding this matter. Anything anybody else wanted to say before the court makes its ruling and determination?
Yeah, I think we could probably rest on the briefs just in the interest of judicial economy. And we've already had oral argument. The court has taken the arguments under advisement. And I think that we can probably prepare for the ruling.
Mr. Jaffe, you want to say anything, sir?
I'm fine.
Thank you. So the court has listened to the arguments on the motions, read the motions, and obviously the motion sounds in a claim under MCR 2116C8 and C10, and is an argument raised by the city of Detroit that the plaintiff has failed to meet the requirements of MCLA 53105, and particularly that the plaintiff has failed to establish the necessity of treatment, or that treatment was kind of causally connected to the automobile accident that dates back to 2016, and that the argument, of course, is that treatment was not necessary, or that the incident was not causally connected. Upon taking of the deposition of the doctor of this matter, the defendant city of Detroit drilled down on this matter and concluded that the doctor was not able to provide information that causally connects the treatment that was tendered to the claimant in this matter. After reading the motion and considering the issues involved, it really becomes a situation where there remains significant questions of fact, arguments, or factual scenarios that a trier of fact should be able to consider in regard to this matter. Number one, while the court does not review this as a res judicata kind of analysis, the fact of the matter is that there was a resolution related to the underlying automobile accident that was tendered to the claimant herein. The claim in this particular lawsuit relates to medication that was provided as a part of that treatment. Now, certainly the court does not conclude that the cause of the case was resolved as it relates to one aspect of the treatment itself, and that this is a claim for medication. Therefore, the claim for medication is validated because the case was settled with regard to some other aspect of it. But I don't think it's active prudence for the court to ignore the factual realities that exist in this particular case based upon the motions and arguments that have been presented by the court. We know from documents presented that the doctor in this particular case has an interest in both entities that were involved in the respective lawsuits, and that the treatment that was directed in this case is associated with the entities that are under some control of management by the doctor who was deposed in this matter. And in being deposed, the doctor concludes, although counsel for the defendant says that it's a speculative conclusion, that his conclusion appears to be that this treatment would be related to the underlying injuries that were secondary to the automobile accident. That's not an ultimate determination this court can make. That raises enough of a factual question that the court should not deprive a trier of fact in determining that particular issue. Mr. Elf has also raised that the subsequent presentation of information regarding the causal connection of this particular event is precluded by an evidentiary rule. Well, I don't know that I could come into agreement with that 100%, but at the same time, that is something that is secondary to the motion for summary disposition. That would certainly be an issue that could be raised where there is the presentation of proofs to support the causal connection of the underlying accident in this matter. The long and short of what I've had to conclude after going over these matters again and again is that there remains significant factual disputes that should be issues that a trier of fact should consider. And for the court to grant the motion for summary disposition, I would I would close the door on that. And I don't think that there is enough here to preclude the claim from going forward based upon the argument regarding lack of causal connection. There is enough evidence to point in the direction that there is a causal connection here, and that is for a trier of fact to ultimately determine that issue. For that reason, or for those reasons, the court will deny the motion for summary disposition in this matter. So,
Thank you, Your Honor.
Thank you, Your Honor.
all right, so
Will
what
the
is
court enter such an order, or do counsel have to submit an order?
I'll issue an order, and you'll get it from me in the next couple of days.
Thank you.
All right, so I know this has been going on a little while, and there's other cases involved, and so on and so forth. So, what's your pleasure, gentlemen? You want me to set this for trial, or do you think some other process may help with this? So, your suggestions?
You know, I would say this, that the other case was resolved at it was resolved prior to trial. I'm open to a facilitation if that's what Mr. Ashew wants to do, if he isn't so inclined. But I would defer to Mr. Ashew to see what his preference is.
Your Honor, I would ask that it be set for trial. There's nothing that prevents the parties from reaching a pretrial resolution if we are so inclined in the meantime.
All right, so I'll go ahead and set it for trial. If you wanted me to sign an order for facilitation and still keep a trial date attached to it, we could do both. Mr. Ashew, any thoughts about facilitation?
Not really interested in facilitation at this time, especially if it's non-binding. I mean, it's not really something that we're interested in at this time.
I could also do an order for mediation. That would be an alternative as well. And
I would propose to the court some form of alternate dispute resolution before just showing up for a trial date, Your Honor.
yeah, and that's kind of what I'm reaching at. Again, I'll set it for trial, and the two of you. I mean, I'll be glad to sign some kind of order to assist in that regard. But I'm sure that the two of you can reach out to each other and perhaps figure out if this is something we're trying to reach a resolution on short of that trial. So maybe set it on trial 60 days out.
Judge, I believe this is a jury trial, is it not?
I'm sure it is, man.
I don't think there was a jury demand unless plaintiff filed it.
Let me take a quick look, gentlemen. Well, I don't see a jury demand. The plaintiff did not file for jury demand, and I don't see a demand with the.
Yeah, we didn't file one. So
Okay, well, then there isn't one, right?
Well, you got May the 23rd.
May 23rd is when I can do it, gentlemen.
Judge, I already have a trial scheduled in the 15th District Court beginning on May the 23rd.
But those little courts can't take priority over this. When is that trial? When does that trial start? In May 23rd, you said?
Monday, May 23rd, yes, it's a jury trial.
Oh, May 12th then. May 12th.
May 12th is fine.
All right, May 12th, 10 o'clock p.m.
that's fine.
All right, gentlemen, you'll get an order for me with the trial date as well as with the order denying the motion for summary disposition. And I'll see you on that date, I'm sure. I'm sure I'll see you before then, and I'll see you on that date regardless.
Thank you, Your Honor.
Thank you.
All right, regarding the suffix 872, that's Community Alliance versus Lawrence Gist. Also concerning the suffix 346, that's Michigan Basic Property versus Bureau Henry. And also regarding the suffix 927, that's Monroe Community Credit Union versus Michael James Discus. In each of those matters, it was set on for hearing on a issue on the issuance of a subpoena this morning at 9:30 a.m. In each matter, the plaintiff did not appear, and the defendant did not appear either. So the subpoenas in these matters will be dismissed in each matter. So and those dismissals are on the failure of the plaintiff to appear.
Okay.
Yeah,
Let's see here.
he's downstairs. He was,
That's it.
yeah, he said he went down there to help or something.
Oh, you can tell.
He didn't say he didn't tell nobody, so that's why I thought he was absent. I just
You
said.
need to be in this court.
He said he didn't have any help.
Did y'all go to the thing for Judge Shakur yesterday?
I didn't.
Okay.